Good day, everyone. This is Arogo Speaks on Arogo Insights. Today, we'll be talking about something very key and important in contract law, and that is the terms and vitiating factors of a contract under Nigerian law. Contracts, as we all know, form the bedrock of commercial and personal transactions in Nigeria, governed by principles derived from the English common law, statutes, and judicial precedents. What we're going to examine this day are the terms of a contract, which are express and implied terms, conditions, warranties, and innominate terms. And then we'll look at vitiating factors like mistake, misrepresentation, duress, undue influence, and illegality. And then we'll consider the remedies for breach of contract under Nigerian law. And in doing this, we'll be drawing on relevant legislation such as the Sale of Goods Act 1893, which is a statute of general application. We'll look at Nigerian case law like Baba and the Nigerian Civil Service Commission. And then we would look at influential UK cases like the famous decision in Headley and Baxendale, decided in 1854. And then we will provide a critical analysis of how these terms shape contractual obligations and enforceability. Here, this discussion will underscore the balance between freedom of contract and equitable protections, offering insights for legal practitioners and scholars. What we know as a contract has been defined in this lecture series, but at the risk of repetition, I will just say that a contract is a legally enforceable agreement creating mutual obligations between parties. In Nigeria, contracts require offer, acceptance, consideration, intention to create legal relations, and then you cap it up with the capacity of the parties to contract. The terms of a contract define the parties' obligations. While vitiating factors may render a contract void, voidable, or unenforceable, remedies for breach ensure justice for the innocent party. This class will explore the classification of contractual terms, express and implied, condition, warranties, and innominate terms, vitiating factors like mistake, misrepresentation, duress, undue influence, and illegality, and then the remedies for breach with reference to Nigerian and UK case law and statutory provisions. Terms of a contract. Contractual terms delineate the rights and obligations of the parties. They are classified as express or implied and further categorized as conditions, warranties, or innominate terms based on their significance. What are express terms? Express terms are terms that are explicitly agreed on by the parties, whether orally or in writing, reflecting their intentions at the time of contracting. These terms may include the price, the delivery timelines, or specific obligations in Beaumont Resources Limited and DW Drilling, a 2016 decision. The Court of Appeal held that courts are bound to enforce express terms unless vitiated by fraud, misrepresentation, or illegality, emphasizing the sanctity of contractual agreements. Implied terms. Implied terms are incorporated into contracts by statute, courts, custom, or conduct to ensure fairness or business efficacy, and they include, for example, terms that are implied by statute. The Sale of Goods Act 1893, applicable in some Nigerian states, implies the terms into contracts for the sale of goods. For example, if you look at Section 12, Sub 1 of the Sale of Goods Act, it implies a condition that the seller has the right to sell, while in Section 12, Sub 2, it implies a warranty of quiet possession. In Akoshile and Ogidan, a 2000 decision, the court upheld the implied condition of title when a stolen good was sold, allowing the buyer to recover damages upon repossession. Terms implied by courts. Courts imply terms to give effect to the parties' presumed intentions or ensure business efficacy. In the Moorcock, a decision of the United Kingdom passed in 1889, the court implied a term that a wharf was safe for mooring to achieve the contract word purpose. Again, terms can be implied by custom or trade usage. Terms common in a trade or locality may be implied unless excluded. In Houghton and Warren, another decision of the UK, decided in 1836, a term was implied based on custom, entitling a tenant to an allowance for seeds and labor. And then terms that are implied by conduct. Conduct may imply agreement on certain terms, as seen in Brogden and the Metropolitan Railway Company, decided in 1877 in the UK. Parties may exclude implied terms, but statutory implied terms in consumer contracts are often non-excludable, like the Section 12 of the Sale of Goods Act that we just talked about. Now, we will now move on to warranties, conditions, and innominate terms. The significance of a term determines the remedy for its breach. When it is a condition, these are fundamental terms, and their breach allows the innocent party to terminate the contract and claim damages. If you look at Section 11, Sub 1B of the Sale of Goods Act, it classifies certain terms. Example, the delivery time in commercial contracts as conditions. In Pinnock Brothers and Lewis and Pitt, a 1956 UK decision, the court held that delivering defective goods breached a condition justifying repudiation. And then we move over to warranties. These are subsidiary terms, and their breach entitles the innocent party to damages but not termination. If you look at Section 11, Sub 1 of the Sale of Goods, it classifies terms like minor defects as warranties. And then, what then are innominate terms? These terms classification depends on the breach's effect. If the breach deprives the innocent party of substantially the whole benefit, it is treated as a condition, otherwise it is a warranty. In Hong Kong Fresh Shipping Company Limited and Kawasaki Kisen Kaisha Limited, a 1962 decision of the Queen's Bench in the United Kingdom, the court introduced flexible approach influential in Nigerian law. Then we will move to vitiating factors. Vitiating factors undermine the validity of the contract or its enforceability. In Nigerian law, these include mistake, misrepresentation, duress, undue influence, and illegality. Let us look at mistake. Mistake occurs when parties enter into a contract under a false belief about a fundamental fact. Mistake may be common. That is when both parties share the same mistake. Example, the subject matter does not exist. When you speak Latin, you say res extincta. In Courtier and Hassel, decided in 1856, in the United Kingdom, a contract for non-existent corn was declared void. Mutual mistake. Here, parties misunderstood each other's intention, negating consensus addendum. That's the meeting of the two minds. For there to be a contract, there must be the meeting of the two minds. Consensus addendum, agreement. Unilateral mistake. In this case, one party is mistaken and the other knows or ought to know of the mistake. In Condi and Lindsay, decided in 1878 by the UK courts, a contract was void due to a mistake about the buyer's identity. And then you look at mistake in equity. In Sole and Butcher, decided in 1950, again, another decision from the UK, a lease was set aside for mutual mistake about rent control, showing the role equity can play in granting rescission for non-fundamental mistakes. And then we will talk about the plea of non ex factum that applies if a party signs a contract under a fundamental mistake about its nature, provided they were not careless. You are not careless on your own part. You've done your due diligence, and then you discover that you signed the contract under a fundamental mistake. You can lead evidence to show that that was done by mistake and that your signature on the document is not actually what you intended, if you had known what happened. It's called the plea of non ex factum. And then we will talk about misrepresentation. Misrepresentation involves a false statement of fact or law, inducing a party to enter a contract. It may be fraudulent, made knowingly or recklessly, attracting rescission and damages in tort for deceit. In Derry and Peak, decided in 1889, again in the United Kingdom, the court defined fraudulent word misrepresentation. And then when the misrepresentation is due to negligence, made without reasonable grounds for beliefs, allowing rescission and Damages in Udoku and Oki, a 1977 decision of the Nigerian court, the court considered remedies for what? Misrepresentation. And then innocent misrepresentation, made honestly with reasonable grounds, allowing rescission or damages in lieu at the court's discretion. This is exemplified in Leaf and International Galleries, a 1950 decision of the United Kingdom. Here, the statement must be of fact, not opinion or intention, unless the intention was dishonestly held. For example, in Eglinton and Fitzmaurice, an 1885 decision of the United Kingdom, rescission may be barred by affirmation, delay, or third-party rights. Now, what then is duress? Duress involves caution, depriving a party of free will, rendering the contract voidable. For it to be duress, it may be physical, that is threats or violence, like somebody placing a gun on you and asking you to sign a document. It may be duress too if it is economic in nature, for example, illegitimate pressure. In Barton and Armstrong, decided in 1978 by the appeals court in England, threats of violence vitiated the contract. Economic duress requires illegitimate pressure and no reasonable alternative, as discussed in Oil Serve Limited and NNPC. Remedies include rescission and damages for losses caused by the duress. Let us move on to the other vitiating factor, which is undue influence. Undue influence occurs when a party exploits a relationship of trust or dominance, making the contract voidable. It may be actual, that is, explicit pressure is proven. It may be presumed, like in relationship of trust, example, solicitor-client. Undue influence is presumed unless rebutted by evidence of independent advice. In Royal Bank of Scotland and Etheridge 2002 decision of the United Kingdom, lenders were required to ensure independent advice in non-commercial security contracts. Rescission is the primary remedy, but it may be lost if restitution is impossible or the contract is affirmed. We move to illegality. Illegal contracts, simply speak, are unenforceable if they involve unlawful acts or contravene public policy. Illegality arises by statute. That is when a contract is prohibited by statute. They are all void. In Shodipo and Lemmy Kainin, the Nigerian courts in 1986 held a foreign currency loan contract without ministerial approval illegal under the Foreign Exchange Act of 1962. At common law, a contract to commit crimes or defraud are unenforceable, as shown in Alexander and Racing, a decision that was passed in 1936 by the UK courts. The in pari delicto rule prevents recovery in illegal contracts where both parties are culpable. In Mohammed and Farah Hussein Jama, a 2003 decision, in Ajaokuta Steel Company Limited and Incorporated Institute Limited, an insurance contract without premium payment was unenforceable under the Insurance Act, despite illegality not being what pleaded. Now, what are the remedies for breach of contract? Breach of contract occurs when a party fails to perform their obligation. Nigerian law provides remedies to compensate the innocent party or enforce what performance. We will talk about the barber of them all, damages. Damages compensate for losses caused by the breach. In Hadley and Bagzendale, decided in 1854, the court established two limbs that the damages, for damages to accrue, you must have incurred direct losses, that is, losses naturally arising from the breach, and then consequential losses, losses contemplated by both parties at the time of contracting. In Baba and the Nigerian Civil Service Commission, the Supreme Court awarded damages for wrongful termination, calculating losses based on the salary of the plaintiff and benefits, reinforcing the compensatory word principle. Then, after damages, we move toward specific performance. Specific performance compels performance of contractual obligations, typically for unique subject matters like land. In Kuri and Kuri, a 1997 decision of the Nigerian courts, the court considered specific performance for an oral land contract, emphasizing the role of equity in ensuring that parties are not unjustly denied the product of their contract. It is discretionary and may be refused if it causes what? Hardship. Rescission. Rescission cancels the contract, restoring the parties to their pre-contractual position. It is available for breaches of condition or vitiating factors like misrepresentation, as decided in Udoku and Oki. Bars to rescission include affirmation or third-party word rights. Injunction. Injunction restrain breaches which are prohibitory or compel performance when the injunction is mandatory. They are rare and discretionary. And then we talk about restitution. Restitution prevents unjust enrichment by requiring the return of benefits under a void contract. In illegal contracts, restitution is generally unavailable under the in pari delicto rule as highlighted in Mohammed and Farah Hussein Jama, a decision of the Nigerian court in 2003. Let us look at what we have discussed. Nigerian courts balance freedom of contract with equitable protections. Cases like Baba Gire and the Nigerian Civil Service Commission emphasize compensatory damages, while Akoshile and Ogidon underscores statutory implied terms. UK cases like Hadley and Bagzendale, Hong Kong Fish Shipping Company and Kawasaki Kisen Kaisha Limited provide doctrinal clarity, shaping the Nigerian jurisprudence. However, Let's take note of this. The narrow scope of mistake and the pari delicto rule can lead to harsh outcomes, suggesting a need for statutory reforms to align with equitable principles as seen in the Misrepresentation Act of 1967 in the United Kingdom. By way of concluding, the terms of a contract, express, implied, conditions, warranties, and innominate terms define parties' obligations, while vitiating factors like mistake representation, duress, undue influence, and illegality challenge enforceability. Remedies such as damages, specific performance, and rescission ensure justice. Nigerian case law, supported by UK precedents and statutes like the Sale of Goods Act 1893, a statute of general application, provides a robust framework for contractual disputes. We must draft clear terms and advise clients on vitiating factors to ensure enforceability of contract. You are listening to us today because you may have stumbled on this video or you have already subscribed to our channel. If you have not, please make our time and subscribe to our channel. You can follow us on all our social media handles on X, Instagram, Facebook, YouTube, TikTok. Your support and comments and likes will make this program better, and we look forward to it. We appreciate you for what you guys are doing. Thank you, and God bless you.
The show that shines the light.